Hello everyone, welcome to Advanced Knowledge Systems and a warm welcome to AKS IAS Academy, which offers examination coaching for UPSC CSE, State Public Service Commission, SSC Combined Graduate Level and CLAT examinations. And about me, I'm Sandeep Bhushan and I take up the analysis of the Hindu newspaper, that is daily news analysis of today's, that is 5th of April 2021. And throughout my session, I would be emphasizing on the keywords and key phrases from the Hindu newspaper, wherein we will identify the factual, analytical and conceptual questions which are critical for UPSC prelims perspective. And while you imbibe the keywords and the key phrases in your answer writing for the mains examination, your answers would be precise and concise and thereby would score higher marks in the mains examination. So therefore, this session at AKS IAS Academy will certainly help you to crack both prelims and mains of 2021. And before we get into the DNA of the newspaper, we would be focusing at the quote of the day. And the quote of the day says that the secret of your future is hidden in your daily routine. So what is important is that you need to stick to your daily routine, and that will definitely set a path to your success. And now we'll focus at the newspaper, that is the DNA. And here we can look at the induction of the Rafale jets. And in regards to the Rafale jets, Indian Air Force has inducted a batch of 5 Rafale fighter jets out of the 36 contracted by India from the France under 7.87 billion euros, which is an intergovernmental agreement which has been signed in the year September 2016 with the India specific enhancements. So therefore, this 36 Rafale contract from France is an intergovernmental agreement. So this is a key phrase what you need to understand for prelims, as well as the conceptual understanding of the Rafale jets, fighter jets, which have been inducted by the Indian Air Force. That is the intergovernmental agreement with the 13 India specific enhancements. And the first batch of the 5 jets, that is in the 5 jets, fighter jets, there were 3 were single seat and 2 were twin seater trainer, and they were the first batch of the Rafale jets were formally inducted into a squadron that the name of the squadron is called as number 17 Golden Arrow Squadron. And this is the keyword which you need to focus for the prelims perspective, that the first formally inducted Rafale jets were in which of the following squadron, or which of the following statements are incorrect in regards to the first 5 jets which were formally inducted. It was number 17 Golden Arrow Squadron, and it was in the year September 20 at the Air Force Station called as Ambala Air Force Station. So these are the key words which you need to focus for prelims UPSC perspective. And the first batch of the 5 jets have arrived in India in July 2020, and this has happened with a stopover at United Arab Emirates, and it had a stopover at an airbase called as Al Dhafra airbase. And this is again the airbase which there was a stopover for the 5 jets which has started or which have initiated from France to India, and the stopover was at UAE. So these are the crucial information for prelims perspective. That is in regards to the intergovernmental agreement, and the squadron is 17 Golden Arrow Squadron, and the stopover was at Al Dhafra Air Base. And during the first leg, that is the first 5 fighter jets which have been flown from France to India, it was started at Merignac Air Base at Bordeaux in France. So this is again another keyword which you need to focus for prelims, from where it has, the fighter jets have initiated the first leg is from Merignac Air Base at Bordeaux in France to the UAE, and from UAE again it was to India. And while it was from the Marignac Air Base to UAE, the 5 fighter jets were accompanied by the French Air Force mid-air refuelers. Again from UAE to India, the 5 fighter jets were accompanied by IAF mid-air refuelers. So here the concept what you need to understand is, for prelims perspective, is which were the one which have accompanied the first fighter jets to India, where the French Air Force mid-air refuelers, they have accompanied the fighter jets from France to UAE, and again from UAE to India, the journey for the first fighter jets were accompanied by IAF mid-air refuelers. So this is the crucial and critical information for prelims UPSC perspective, that which among the following statements are incorrect. And again, addition to the first leg of the flight of the fighter jets from France to India, now India will also receive another 8 to 9 Rafale jets from France in the mid-May. And this month also there are a couple of Rafale jets which are again being flown to India, and by this the Rafale jets which will arrive in India will complete the first squadron of the fighters of the Indian Air Force. So the first squadron wherein the fighter jets were inducted was in the Golden Arrow Squadron. So these are the crucial information for prelims perspective. And with this induction of the fighter jets in the month of April, now with this the first squadron will be completed, and with the completion of the first squadron, India or Indian Air Force will have 14 jets out of the 36 contract which India had with France. And the Air Force or the Indian Air Force is set to operationalize the second Rafale squadron at Hasimari in West Bengal. And the Indian Air Force Chief, that is Air Chief Marshal, has said that Indian Air Force would get 3 to 4 Rafales every 2 to 3 months. That means it is a continuous process that India would receive the fighter jets from France, that is Rafale fighter jets from France, every 2 to 3 months. 3 to 4 Rafales will be delivered and it would be added to the first squadron, and then again the first squadron would be fully ready by the year or the end of 2021, and the second squadron will be ready by the year 2023. So this is crucial for prelims perspective, and this is in regards to the defense, Indian defense, and also in regards to the national security. National security, because as we are encountering the skirmishes along the LAC between India and China, and also the LOC between India and Pakistan. And there is another news in regards to the adoption, and the Delhi High Court has issued a notice to the adoption authority, and we will look at what is the Delhi High Court, on what basis it has issued a notice to the Central Adoption Research Authority, that is CARA. So the Delhi High Court has issued notice to the Central Adoption Resource Authority because there was a plea which was submitted by an Hindu couple who is living in the US, and they seek, this Hindu couple who are living in US, they seek a no objection certificate, NOC, to adopt a child who was born to a Christian parents. And because of the plea which has been petitioned by the Hindu couple, the Delhi High Court has further looked into the case and issued notice to the Central Adoption Resource Authority. And now we will look at what is the entire intricacy of this Delhi High Court issuing a notice to the Central Adoption Resource Authority. And if you look at the present plea or the petition, the present petition raises an issue which is an enormous importance, which is relating to the legal vacuum, which is in respect to the adoption, which has been taken up prior to the Juvenile Justice Care and Protection of Children Model Rules of 2016. That means This Juvenile Justice Act 2016 has come into existence in regards to the specifications of the adoptions, or else the adoptions to be carried out has been put very stricter. But there is a legal vacuum before the adoption process of the Juvenile Justice Model Rules 2016. Please do understand this key phrase. That is, now we would be focusing what are the legal vacuum before the implementation or coming into force of the Juvenile Justice Care and Protection of Children Model Rules of 2016. And if you focus this, the adoption by the couple, that is the US couple, has totally been taken up. The process has been taken up in the year 2014. That means the couple has adopted a minor child who was born on December 11, 2014. Please do understand the model rules of 2016, that is Juvenile Justice Act 2016. But there is a legal vacuum prior to the Juvenile Justice Act of 2016. That is why we are looking into the what the Delhi High Court has issued notice to CARA. That is in regards to the couple being, adopted a minor child who was born on December 11, 2014, and the entire adoption deed has witnessed by the village sarpanch and by the relative, that is a social worker, and the entire adoption deed was registered on December 8, 2014. And when it was registered, that is the adoption deed which was registered on December 18, 2014, it was registered under the provisions of Hindu Adoption and Maintenance Act of 1956. So this is a key phrase. So now we will be focusing at the Juvenile Justice Protection of Children's Model Rules of 2016, and now with the HAMA, H-A-M-A, that is in regards to the Hindu Adoption and Maintenance Act, HMA 1956. So there is a gap, legal vacuum before the or within the adoption process or the provisions of the Hindu Adoption and Maintenance Act 1956 and the Juvenile Justice Care and Protection of Children's Model Rules 2016. Because the adoption deed was registered before the 2016 model rules on December 18, 2014, that is why there is an issue. And now we will look at what is the issue, why the couple has petitioned, and thereby they have approached the Delhi High Court. And as the couple are the US citizens, they are definitely finding difficult to obtain the passport of the child even till date, because the parents, that is the couple's parents, reside in Kerala and the child is living with the grandparents, that is the parents of the couple. The child who has been adopted is still living in Kerala. That means the child who has been adopted and the adoption deed which was registered on December 18, 2014 is not having or not getting into the provision of issuing a passport to the child, and the child since 2014 till date, that is 2021, is still residing in Kerala, that is in India, with the grandparents, and wherein the couple who are living in US are now pleading, or they have also approached the Firozpur court to grant the declaration that the child has been adopted under the Hindu Adoption and Maintenance Act 1956, and they have to be given the passport so that the child can be moved to US and the child can be with the parents, adopted parents. But in turn, the Firozpur court has refused to grant the declaration because on the grounds of Hindu Adoption and Maintenance Act 1956, it does not apply to Christians. This is the legal vacuum. This is the legal vacuum wherein now the Delhi High Court has issued notice to the CARA, and in turn the couple wanted to obtain a passport for the child, and they have approached the CARA, that is the Central Adoption Resource Authority, on October 2016 to get an NOC, but the Ferozpur court has refused to grant the declaration that the child is being adopted by the Hindu couple which was born to an Christian, and the Kara has rejected. In turn, now after approaching Ferozpur court, they have also approached the Kara, that is the Central Adoption Resource Authority, but in turn the Central Adoption Resource Authority has also rejected the application of the Hindu couple, and in turn this Kara has initiated action against the Hindu couple, the relative and the grandparents of the adopted child. Therefore, now the court or else the entire issue or the petition is with the Delhi High Court, and the Justice Singh of the Delhi High Court has said that the welfare of the child is paramount in such cases, and while focusing on the welfare of the child, the court is also looking into the validity of the rejection of the NOC by the Kara. That is, as the couple has first approached the Ferozpur court, which they were not granted the adoption process to be completed, as it does not apply to Christians as per the Hindu Adoption and Maintenance Act. Then they have approached the Kara. Now the Kara also rejecting the initiation taken by the couple to be granted the passport. Now the court says that the validity of the rejection by the Kara in regards to the no objection certificate is to be examined, and the court has said that the further hearing would be on April 22nd. So here this is a crucial conceptual understanding about the adoption process, that is in regards to focusing the Juvenile Justice Care and Protection of Children Model Rules 2016, and also the Central Adoption Resource Authority, the Delhi High Court, and the Hindu Adoption and Maintenance Act 1956. So all this taking into consideration, you can certainly have a better conceptual understanding about the adoption process from 1956 to 2016, and again in regards to the flaws or the kind of the legal vacuum which is now present, and that is the reason the Delhi High Court has issued notice to Central Adoption Resource Authority finding the validity of the rejection of the LOC, and they are examining the kind of the validity and the welfare of the child is prominent. And now we will focus at the another news in regards to the acquitted of serious crime. Here the Supreme Court has decided or ruled that a public employer can reject a candidate or any candidate as unsuitable for the particular post if he or she had in the past been acquitted is released of a serious crime merely on the benefit of doubt. Here the keyword is benefit of doubt is the keyword. Please do understand, if a candidate or an individual has been acquitted, released of a serious crime merely on a benefit of doubt, in that scenario the public employer can reject a candidate as unsuitable. This is what has been ruled out by the Supreme Court. That is, the bench which has been led by Justice Sanjay Kishan Kaul has said that a person who has been acquitted or released on the benefit of doubt is certainly there is a difference from a person who has been acquitted honorable. So here the key word is benefit of doubt, that is acquitted on the benefit of doubt and acquitted on the honorable acquittal. So there are two keywords here which you need to focus in regards to the word acquitted. So there are two cases wherein a person can be acquitted from a serious crime, that is being as part of the benefit of doubt, and the other one is honorable acquitted. then here in this case, the Supreme Court is very clearly saying that there is a difference when a person is been acquitted based on benefit of doubt and honorable acquittal. And the fact what the court says is acquittal would not suffice, but rather it would depend on whether it is a clean acquittal. This is again another key word, that is the third one, that the fact of the matter is acquittal, but it should depend on whether the individual has been acquitted cleanly, and the clean is based on total absence of evidence. Only in that case a clean acquittal and then honorable acquittal has to take place. And when there is just a benefit of doubt acquittal on the person, in that scenario the public employer can reject a candidate as unsuitable, is the Supreme Court decision. And a person should be honorable acquitted of any serious or heinous crime to be considered eligible for public employment. So the judgment or the rule by the Supreme Court is that a person can be eligible for public employment only when he is honorably acquitted, but the public employer can reject a candidate when a person is acquitted of a serious or heinous crime on the basis of benefit of doubt. So here, as I repeat and reinstate, the two key words are benefit of doubt, acquitted, and the other one is honorably acquitted. And now we'll focus at what is honorable acquittal. And the court has explained in the recent judgment that a person or one who has been accused is acquitted after full consideration of the prosecution evidence, and once he is acquitted after the prosecution evidence and the prosecution when the prosecution has failed miserably to prove the charges levels against the accused. That means when the prosecution does not find the evidence and it has failed to prove the charges which has been leveled against an accused person, in that case, possibly the accused who is being acquitted is called as honorable acquittal or acquitted. He is acquitted honorably. So that means when the prosecution evidence has failed miserably to prove the charges leveled against the accused and he is acquitted in that scenario, this scenario, only then the accused is called as honorable acquitted. And the Supreme Court has also observed that acquittal in criminal cases, just an acquittal in criminal cases, that is release of an accused person in a criminal case, does not automatically entitle a candidate or the person who has been acquitted to the appointment of the post. Please do understand here, the Supreme Court has observed that on the benefit of doubt, if a person is acquitted in a criminal case, it does not automatically entitle that he is eligible for appointment of the post. He would be eligible only when he is accused honorably acquitted, when the accused is honorably acquitted. And this case is concerned to a man who has been acquitted of murder in Rajasthan in the year 2009. And this is the information which is in regards to the polity, especially in regards to the public employment, or the public employer can reject on two bases, that on the basis of benefit of doubt, but if the person, the accused, is acquitted by the court based on honorably acquitted, then there is a possibility that he is considered or eligible for public employment. And the another news is in regards to the how Philippines is still accusing China, the way the China is planning to occupy more areas in the South China Sea. And in regards to this, the Philippines Defense Secretary Delphine Lorenzana has said that China is looking to occupy more areas in the South China Sea. And based on this, he has cited that the China's vessels have entirely taken up the occupation, or they have occupied the area, and the China boats have been manned by militia, and those China's vessels or the boats are now in the disputed parts of the strategic waterway in the South China Sea, which borders Philippines. And the defense minister of Philippines calls for the China's boat to leave or to vacate from the Whitsun Reef. So this is a keyword for geography map based. For geography map based, we need to understand where is Whitsun Reef, and the Philippines Defense Secretary very clearly says that this Whitsun Reef is just within 200 miles of the Julian Philippe Reef, and this Julian Philippe Reef is an exclusive economic zone. So therefore, as it is just within the reach of the exclusive economic zone of the Julian Philippe Reef, the Chinese vessel, so he is demanding that the Chinese vessel should vacate from the disputed parts of the strategic waters or the waterway in the South China Sea. And he also said that China has occupied the disputed areas in the past also, that is at the Panatak Shoal or Bajodi Masinlock and at Paganiban Reef. So in the past, as it has done, the China has now gone ahead with stationing its vessels in the Whitsun Reef. It has done it in the past even in the Panatak Shoal or Bajodi Masinlock and at Pangani Ban Reef. And this has, as per the Philippines Defense Minister, this violates brazenly the Philippines' sovereignty and the sovereign rights under the United Nations Framework Convention on Law of the Sea. That is the international law. That is, as per the United Nations Framework Convention on Law of Sea, the Philippines says that it is also the sovereign rights of Philippines under the international law. And it says that in the past, the International Tribunal has also invalidated China's claim of 90% of the South China Sea in the year 2016. But in spite of the International Tribunal favoring in regards to the Philippines and against China or China's claim in the South China Sea, but still China is not recognizing the ruling of the International Tribunal. And in turn, China has gone ahead with building the artificial islands in the disputed waters of the South China Sea. And in turn, they have been equipped, that is, the artificial islands have been equipped with radars, missile batteries, and hangars for the fighter jets, which in the artificial islands which have been built by the China in the disputed waters of the South China Sea. That is what the Philippines Defense Minister is making a point in regards to the earlier occupying the disputed waters by China and not recognizing the International Tribunal. The Chinese diplomat in regards to this, or in regards to the statement made by Philippines Defense Minister, the Chinese diplomats have said that the boats or the vessels, China vessels, have anchored near the Whitsun Reef because they were sheltering from the rough weathers of the sea, and they say that there is no militia on board of the Chinese vessel in the Whitsun Reef, but they are just taking shelter to overcome the rough seas of the area. So this is as per the international relations or the China's dominant role in South China Sea. And we'll just focus at from geography map based. So this is Philippines, Manila, and then if you look at this area is the Whitsun Reef, which is in this shape, boomerang shape. And now when we are talking about Julian Philippe Reef, which is an exclusive economic zone, which the Philippines Defense Minister has said belongs to Calayan Islands, and this is the exclusive economic zone. So we have seen the strategy used by China is to make sure that they are having control of the exclusive economic zones in South China Sea, and in turn they are going ahead with building artificial islands which are close to the exclusive economic zones in South China Sea. And we have seen that as in the past also, the China has occupied, or it has come up with trying to occupy the reefs in the year 2016 is Panganiban Reef in the Philippines or in the South China Sea. So this is, you can consider these maps for geography map base for prelims perspective for a better conceptual understanding. And I hope this session was informative, knowledgeable, and also very critical information provided for mains and as well as prelims perspective. So I would say a very big thank you to all. Good luck to you all. Do maintain consistency, stick to your schedule, and take care of your physical health and mental health. And do not forget to like the video, share the video, and subscribe the AKS IAS English Medium YouTube channel, and also have access to the website and to the Telegram link of the AKS IAS Academy, that is the advanced knowledge system. And then see you again tomorrow with the daily news analysis at AKS IAS Academy. Till then, thank you, goodbye, and then take care.